So without further ado, David Phillips Jones, QC, draws his expertise not only from the practice of law, but as a former law professor. He grew up here in Calgary and studied economics and political science at McGill University. He then studied law as a Rhodes Scholar at Oxford. For 16 years, he was a full-time law professor at McGill and the University of Alberta, teaching administrative law, constitutional law, property, taxation, and government control of business. In 1988, he went into private practice in Edmonton with his wife to create the cerebral micro firm of DeVille Jean, right? He is co-author of Jones and DeViller's Principles of Administrative Law, 6th edition, 2014, co-editor of the Administrative Law Reports, and frequent author of legal articles and presentations. He was the co-recipient of the 2009 Medal from the Council of Canadian Administrative Tribunals, and in 2012 he received the Distinguished Service Award for Legal Scholarship from the Law Society of Alberta and the Alberta branch of the Canadian Bar Association. He is one of the foremost administrative lawyers in Canada. We are very lucky to have him here. His legal wisdom is represented across Canada. He is the Conflict of Interest Commissioner for the Yukon and the NWT, Chancellor of the Anglican Church of Canada, and a chartered arbitrator. His practice includes all areas of administrative law, commercial, labor arbitration, and points of law litigation. So welcome and thank you.
Thank you for inviting me to talk to you tonight. I am a ham, and I liked teaching very much, but I hated marking exams. So that's why I went into private practice, where I don't have to mark exams, and I can write textbooks, and I can do talks, and I can write factums for judges, and if they agree with us, they can be in the main part of the next edition of the text, and if they disagree, they can be in a footnote. I know some people here, and I know something about your organization. I know Deborah Howes for many, many years from some of my arbitration work and other work. I don't think Archie Zariski remembers me, but many years ago our paths crossed when we were both doing some tax work or something some long time ago. And Anton Melnick is a fellow arbitrator, so many of you and I have crossed paths over time. Your evening tonight is a very welcoming, warm evening, and a number of you have accomplished very significant work in training for the administrative process. And those of you who are here, but also many of who were not here who completed the certificates, that's an accomplishment. And it's something that we don't often think about as we carry on in our various lives, but the need to think systematically and systemically about what administrative justice is, what the public requires as you do your various different jobs, or if you're an advocate in front of various tribunals and so on, and the quality of the work that is done in the administrative process is extraordinarily important to our society. And it's not just the court work. The court work's the very top of the iceberg. It's the whole rest of the iceberg is the administrative justice side of things. I think you have a copy of my paper available to you on the web page. I give a paper every November to the national section of the Canadian Bar Association in administrative law, and I shamelessly recycle it. But I'm not going to give you that paper tonight. I'm going to, first of all, it's too detailed, and secondly, it is too recent in a certain way. And I thought what I'd do is I would talk about 3 or perhaps 4 broader topics that might be of interest to you, and you can go away and read the paper, and it's guaranteed to put you to sleep. Read the footnotes, they're important. The first topic I want to talk about is standards of review. And by that, we mean when a matter goes to court, and in a minute you'll see I don't just restrict it to court, but typically it's when it goes to court. What is the court to do? What standard is it to apply in looking at the decision that comes in front of it? What's the test? What's it asking itself? Is it asking itself, is that decision correct as we, the reviewing court, think? Or is it a reasonable decision and it doesn't actually matter much what we think? It's the question of, is it reasonable? There have to be some boundaries for constitutional reasons and practical reasons. There have to be some boundaries to what administrative bodies do. We usually call that jurisdiction or true jurisdiction. But within those boundaries, where the legislature has given authority to statutory delegates, and I use that word rather than tribunals because the power can authorize all kinds of things. They're the great standing tribunals of our society. There's the Workers' Compensation Board and its Appeals Commission, and the Labor Board, and the Securities Commission, and so on. But there are many other bodies or people who make decisions, usually adjudicative decisions, not always, sometimes investigative, sometimes policymakers. And those derive their authority from the legislature. And the principles of administrative law also apply to at least the procedural parts of them, to private bodies as well. So if somebody were to be expelled from this organization, the principles of natural justice or procedural fairness would apply to the process for doing that. And professional discipline matters. All the professions that we have organized, the 27 under the Health Professions Act, the Legal Profession Act, the Chartered Accountants Act, CPA, somebody's CPA, Alberta, I know a lot about it, a joint venture.
Yes. Till July.
And their disciplinary powers and how they come together in that particular example, are the engineers, are the architects. All of those, when they do their work, they're living and breathing and working out administrative justice. So standards of review is when there's a problem and when there's an issue and something goes to court, what's the court to do? In 2008, traditionally there were 3 standards of review there in administrative law. There was correctness. That meant that the supervising court decided for itself what the right answer was, and that usually dealt with questions of law or jurisdiction or authority. Or there was the standard of reasonableness, which was, you'll recall in a minute, there are actually 2 meanings to the word reasonableness, but there were, which might be unreasonable in itself, and certainly incorrect. Whether the reasons that were given were rational and intelligible and justifiable. And there was patent unreasonableness, where there was a privative clause where the legislature said, courts stay out. And the courts would stay out unless the decision was patently unreasonable, that the legislature could never have intended that to be what was done. And that tended to look at the merits of the decision. Were they unreasonable, not an outcome that could reasonably be expected? People like me have spent whole careers trying to sort out standards of review. In 2008, in a case called Dunsmuir, the Supreme Court of Canada, quote, simplified, maybe, the standards of review analysis and amalgamated the 3 standards of review, former standards of review, into 2, correctness, which is not often applied, and reasonableness, which was a combination of patent unreasonableness and the other reasonableness, which you might call reasonableness simpliciter. Patent unreasonableness might be reasonableness complexiter, not simpliciter. But both were made into a reasonable standard of review. And the Supreme Court of Canada said correctness would apply to true questions of jurisdiction, so not every legal problem issue, every legal error is a jurisdictional error, which is a whole mind shift from what the law had been in the 1960s and early 1970s. And secondly, it said that correctness would apply to questions of law of general importance to the legal system as a whole. But if it wasn't of general importance to the legal system as a whole, no matter how important it was, correctness would not apply to it. So a good example is an assessment review board for property taxes. Some legal issue arises in that may be absolutely critically important in that context, but it's not important to the legal system as a whole. So there's been quite a bit of fight since 2008. So what would be an example of something that would be of a question of law of general importance to the legal system as a whole? An example I can give you is solicitor-client privilege. Can the Information and Privacy Commissioner require the production of records which are protected by solicitor-client privilege? Well, when that went to court, the question is, so what's the court standard to apply to that? Is it to decide yes or no? And our Court of Appeal ruled in a recent case that I was counsel on that the question of solicitor-client privilege is a matter of general importance to the legal system as a whole, and therefore the correctness standard of review had to apply. There'd be no room for deferring to what the Information and Privacy Commissioner might think about that. And there might be some other matters that would justify the correctness standard of review, but after Dunsmuir, the correctness standard of review, the applicability of it, the application of it, narrowed. It's not as applicable in as wide a range of contexts as it had been before. In a case called, Supreme Court of Canada case in 2011, maybe 12, called Alberta Teachers Association about their newspaper, so we call it the Alberta ATA News case involving the Privacy Commissioner. She and her predecessor generated a lot of really interesting jurisprudence. The Justice Rothstein, speaking for the majority of the court, said that there should be a presumption that the standard of review is reasonableness, not correctness. And if it's reasonableness, that he said that Dunsmuir contemplated that reasonableness would be the standard of review, and that but that it could be rebutted. So it's a rebuttable presumption, but it's a presumption. Justice Cromwell, concurring in the outcome, but not in the reasoning, said, but you know, there are limitations about what the statutory delegate can do, and they must be right in whether they're within those limitations or not in those limitations. And the place that you would find those limitations are in the statute itself that creates the body that's doing what it's doing. So ATA News often stands for the principle that reasonableness will be standard review. And of course, reasonableness implies deference, so that the reviewing court doesn't ask, is it correct? They ask, is it reasonable? And it's irrelevant whether they think it's correct or not. The ATA News stood for the proposition that reasonableness is the presumptive standard of review of a question of law, involving the interpretation of the the tribunal's constituent legislation or related legislation. But Justice Cromwell said, but where would you find limitations apart from being in the statute itself? So there's a difference there about the breadth of the circumstances when correctness would apply. Well, what do we mean by reasonableness in the Dunsmuir sense? What we mean is a decision that is intelligible and justifiable, and has and is an outcome that is acceptable, open within the legal and factual framework in front of the body. So it's actually picks up both parts of the two deferential standards of review before. One might have thought that if the standard of review, which was fought about enormously for years and years and years, if the standard of review was reasonableness, that would be determined to be reasonableness, that would be the end of it. But it isn't the end of it, because you then have to determine, is the decision reasonable? It's not enough to just determine what the standard of review is, you have to determine, is the standard met? So the courts, when they determine that that the standard of review is reasonableness, the courts aren't blind or adopt the ostrich approach of not looking at it further. They look at it further to determine whether the decision is intelligible and justifiable in light of the whole statutory and common law context in which it's found and the factual matrix in which it's found. The courts tend to defer to factual findings of statutory delegates, provided the process is fair on that. The overriding organizing concept about standards of review is this: what did the legislature intend the reviewing body, usually a court, but I'll give you an example of something else in a minute, what did the legislature intend that reviewing body to do? And of course the legislature could say, we intend you to review this decision of your own merits, your own headlights, your own heart, your own decision. You do what you think is right. That's a correctness standard. Or it could say, just keep out of this, just totally keep out of this, unless it's just off the wall, in which case we'll let you go in. But you better be able to justify going in to do that. So the polar star of determining the applicable standard review is legislative intent. The problem is legislature so very seldom tells you explicitly what it intended. The issue arises in a very interesting context where the administrative structure, the scheme, provides for an appeal from one administrator to another, not to a court, either by an appeal, statutory appeal, or by judicial review, but to an administrator. And a good example of that is in professional discipline. Usually there's, where something happens, it's gone through a filter and everything, but when it finally ends in front of a hearing committee, it will make a decision. The hearing tribunal, the discipline tribunal, it will make a decision. And there may be a right of appeal, and rights of appeal only exist if they're granted by statute. They don't otherwise exist, but assume that there's a right of appeal to another administrative body. So for example, in the architect's legislation, there's the discipline committee, and if they decide something, then there's an appeal by the member, by the architect. There isn't an appeal by the prosecutor, there isn't an appeal by the complainant, but there is an appeal by the architect member who's been disciplined to the appeal tribunal, and it can appeal both against the finding of conduct deserving of sanction or against the sanction itself. That administrative appellate body is made up of a different group of people, obviously, or the rule against bias would be tripped. And but the question is, so what does the administrative appellate body do? What standard of review does it apply? It's not going to hear the whole matter again, it's not going to hear the witnesses all over again, but there probably is a transcript, and there are findings of fact that will have been made by hopefully, will have been made by the first body, and usually the appellate body won't second guess those findings of fact unless they're outside the range of reasonableness. So, you know, if you had 10 witnesses going one way about a particular matter and an 11th going the other way, and they decided for the 11th, that panel better tell you in pretty convincing terms why it did it. It can do it, but it must be pretty convincing as to why it did it. So is the appellate body to defer, or is it to decide of its own accord what is the right answer? And we've had quite a bit of litigation about that in Alberta in the context of the Law Enforcement Review Board, which reviews decisions, disciplinary decisions against police, usually by the police chief, but sometimes by the police commission. There are different ways to get to it. Different people have a disciplinary authority. And our Court of Appeal has said that the standards of review analysis that applies in judicial review and court appeals applies at that level as well. And they have said that the presumptive standard of review is reasonableness. So the administrative appellate body is to ask itself, is this decision reasonable of the first level decision? Is it reasonable in light of everything that happened? And of course, determining whether something is reasonable requires one to know the whole context. You need to know the whole statute. You need to know the whole common law. and you need to know the facts. So as an advocate, one of the things that I do when I go to court, regardless of which side I'm on, and our firm is quintessential taxi cab, whoever gets to us first will represent you, if you can pay our bill. We'll give you terms. So we are in all sorts of different contexts. But you have to remember that statutes don't arise in a vacuum. They arise in a common law context. They may arise in the context of a series of statutes. And the facts may set their own context as well. So in making a decision, you have to take all of that into effect, and interpreting a statute, you have to take all of that into effect. And I was pleased to see that one of your components here is interpreting legislation, because that is challenging. It's not a mathematical formula, and it doesn't just take into account the words on the page. You have to know the context of this provision we're fighting about in the whole statute. And when we prepare our briefs, we explain the whole statute and, if relevant, the whole common law background, because you can't count on a judge ever having had any experience at all with that statutory context, or if they did, that they're up to date on what that is. And I'll give you two examples on that. Information and privacy, FOIP, it's a TIPA in some places. There are almost no lawyers who've had anything to do with it in their practice, and there are very few judges who've had anything in practice. And of course, you don't get to pick your judge. You get whichever one is assigned. So out of the 85 Court of Queen's Bench judges, chance of getting somebody who knows something about it is about 0. Maybe as time goes on, a lot of time goes on. We're now 20 years into it. I don't know how many more years you would need to have far more expertise and experience. But so it's very important when you have that kind of case to be able to explain, here's the statute, here's the framework of the statute, here's how it all works, and here, by the way, is how this particular provision fits within that. Because otherwise, the judge just doesn't have any concept of that. And that may very often tell you what the interpretation is, which is actually a different interpretation than you would have thought had you just read the words by themselves. Second example is workers' compensation. Every lawyer knows about workers' compensation, right? But they don't know the details of it, and they don't know how it's changed over time and how it in fact works. So if you're involved in that sort of context, you need to again explain that to the reviewing judge so that they know what it is they're talking about. And of course, when you are doing that, it gives you great ability to characterize, contextualize. I won't say spin, but it might be very helpful to put it in ways that incline the person reading it to understand why you were there and what the point is. And somebody else might try to put it in a somewhat different way. I want to leave standards of review for a minute and talk about a couple of other aspects of administrative law that have changed over my career in administrative law, which is now about 40 years. And it's interesting to compare the 6th edition of the book, which was published, by the way, it's the book with a capital T, the book, which was published in 2014, to the 1st edition of the book, which was published in 1985. So over a period of about 30 years. And just look at the two and say, so what were the issues in 1985? And how have those issues developed, if they have developed, and how have some of those issues dropped off the table, and how are there some new issues? Standards of review wasn't mentioned in the 1st edition of the book. It wasn't mentioned in the 2nd edition of the book. It was mentioned passingly in the 3rd edition of the book, and a lot of it in the 4th, 5th, and 6th. It's just very interesting to see how things have developed. The next topic I want to talk about is the role of decision makers in subsequent court applications. somebody's been ungraceful enough to take your decision to court. And then the question is, so what do you do? Well, the first thing you do if it's an adjudicative decision is you have to prepare a return or a record, or return of the record is the actual phrase. And that includes everything that's relevant to the issue that's being raised from the beginning to the end and the court application itself. And sometimes there are fights about what should be in that and what shouldn't be in that, and the court will settle that if need be. Sometimes the return can be made much smaller. There may be a whole bunch of stuff that is relevant, but it's not material. It doesn't matter to this issue. Yes, it all happened, and you could summarize it in 2 paragraphs, and you don't need pages and pages and pages. I'm dealing with a matter now that involves 13 ministries. They're all the same. Words change, names change, but the issue's the same. It would be stupid to have 13 returns, or a return that's 13 times longer than you need, and you don't actually need all of one. You just need these 6 or 8 documents, and you've got it. But you've filed the return, and you're really unhappy with the people who are unhappy with you. And you therefore think, well, I should go and I should tell the judge why I'm right. And you would be advised not to do that. You might send a lawyer or one of your board members into the courtroom to sit at the back and just listen and make notes. But the leading case is a decision of the Supreme Court of Canada, Northwestern Utilities, which was a rate case of Northwestern Utilities against the Public Utilities Board, where the Act provided that in setting rates, which the courts have described as a quasi-judicial judicative function. You might today have argued about that, you might not have, but that's what they decided. The legislation provided that a utility could not recoup past losses by raising future rates. If they had past losses, they lived with them or without them. And the Supreme Court of Canada, the Public Utilities Board, went in to attempted to argue, well, this isn't a past loss, or this is a past loss, and the utility's wrong in what it's saying, and this is why our decision was right, and court, you should do the same thing. Supreme Court of Canada said, no. You decided what you decided, you have your decision, and we will take your decision on the face of what you said, but you don't get to come here and bootstrap or say it a second time. You've had your opportunity to say it. So that takes you to a couple of things that decision makers need to spend quite a bit of time thinking about. So how do they create a standalone decision so that somebody who doesn't really know anything about this, called a judge, may not be sympathetic, will understand, be able to access what it is and why you decided what you decided. Now, some of the things are repetitive, so you may find ways to short circuit what those are. You may have schedules and so on, but you need to have standalone decisions, and they need to be sufficiently comprehensive that the person reading them knows what the issue was, what was argued, what you considered, what you decided, and why you decided it. And that would comply with Northwestern Utilities because there wouldn't be any need to go there and tell the court why you did all that, right? Because it'd be there. Well, not every case is quasi-judicial in the same way or adjudicative in quite the same way with a lease inter partes in our lawyers' language of me fighting you and judges deciding that. A fair number of administrative things are more distributive or more policy-oriented and so on. Or there may be circumstances where, although it is me fighting you, you're not there. You don't want to come, or for whatever reason. And the decision maker is the only person who can say anything to the court, meaningfully, because they're the only one there. So the courts, particularly in Ontario and to some extent in Alberta, but not at all in British Columbia, have said there may be circumstances where the decision maker can properly make representations to us about what the law is and what the answer is. The case is the Ontario Children's Lawyer case, where there was an issue about the Ontario Children's Lawyer had done various different work. The parents of the children were concerned about the fee of the lawyers involved, and there was a taxation, as we call it, or an assessment of what that fee was, and it went up to court. Well, the parent wasn't able to be there, wasn't interested in being there, but it was an important issue, and if the children's lawyer wasn't there to make representations, the court wouldn't have the advantage of the other side. So the court relaxed the very restrictive rule in Northwestern Utilities and said that the children's lawyer could, with deference and not being in the fray, could make submissions that would help the court understand what the issues are. So if and our case is Leon's Furniture, a privacy case again, where the person who requested the access to information from the public body, actually it was a PIPA case, not a FOIP case, requested access to information of their own personal information from Leon's and complained about Leon's keeping a record of driver's licenses of people who came to collect things later. And it's one thing to show the driver's license, it's another thing for Leon's to keep a copy of it on their records. So there's an issue about that. The person involved who raised all this wasn't there, and Leon's Furniture was there, and the court said that the privacy commissioner, information privacy commissioner, could properly make limited submissions about what the law was and why the law was this way and not that way, and why the decision that the commissioner had made was reasonable. That was the standard review in that case. And I think the answer is, or the test, the standard, the measuring stick, is that the court will allow the decision maker to make limited submissions where doing so would provide added value. But not re-arguing it, not re-justifying, not giving better reasons for what they should have done the first time, and certainly not doing it where you actually have an active other party. Now the problem with the active other party, keeping the decision maker out of it, is it assumes that the other party is going to make all the submissions that the decision maker would make, and that isn't always the case. So that this is an area of law about the role of the decision maker in judicial review that is, I think, not settled yet. I think we're still working out how that's going to work. But it's quite a change in the last 30 years. There's a recent and very interesting variant on this, and that is, so you've been to judicial review and the court struck down your decision. Can you appeal? Can you appeal? You know that the other parties can appeal, but can you appeal? And the answer to that in Alberta anyway is no. And there are two very important cases. One is Brewer against the Alberta Human Rights Commission and Milner Steer, as they then were, Denton's now, where the see if I just get the facts dead right. The chair, the chief commissioner of the Human Rights Commission, didn't like the outcome of a tribunal decision, and he wanted to appeal that decision. The legislature allows an appeal to the Court of Queen's Bench. And the Court of Appeal held, you can't do that. You're the decision maker. Decision maker doesn't get to appeal. And a more recent case was Imperial Oil and the Information and Privacy Commissioner, where there was a decision by the Court of Queen's Bench about settlement privilege, and that was not available. That settlement privilege meant that the records that had been requested by the City of Calgary from Imperial Oil about the area around the Imperial Oil refinery, Lake something in Calgary. The refinery existed when I was a kid growing up there, but the City of Calgary is so big I don't know what's been built there, but it's Lake something. It was polluted, and the Environmental Appeal Board was involved, and they reached a settlement with Imperial Oil, and the City of Calgary wanted access to that information. And the Information Privacy Commissioner said, well, it wasn't privileged, Imperial Oil, and had to disclose it. Imperial Oil had to disclose the information to the city was entitled to it. The Environmental Appeal Board had to do it because it was the public body, had to disclose it to the information to the City of Calgary. Imperial Oil took that to the Court of Appeal. Sorry, the Court of Queen's Bench said it was privileged and the Privacy Commissioner had no ability to order it to be disclosed. And the Privacy Commissioner tried to appeal that to the Court of Appeal. And the Court of Appeal said, no, you're the decision maker. You don't get to appeal this. And that's causing some consternation, I think, in some administrative tribunals. They would be able to appeal if the statute said they could appeal. But you know, in Northwestern Utilities, the statute there, the Public Utilities Act, said that the board was a party to any subsequent litigation, and it had all the rights of a party. So it ought to have been able to say whatever it wanted to say. The Supreme Court of Canada said no, that would impact and adversely impact the neutrality of the board because those parties would have to be back in front of it for other things. It was a continuing relationship, regulated relationship. So there's a role there that requires some care and some thought. Well, that then takes me to reasons and the adequacy of reasons or inadequacy of reasons. And you all know about the principles of natural justice, audi alterum partem, here the other side, and nemo judex in sua causa debet esse, which is the rule against bias. Those are the two great historical principles, and they are all subsumed in the duty to be procedurally fair, to have a fair process. Here the other side, and you can't have a biased decision maker. Well, you go through the process and then there's a decision, a written decision, and it just doesn't make sense to you. How can the court deal with that? Well, first of all, there might be a statutory obligation to give reasons, and you might say that gibberish isn't reasons, and therefore the court can say they aren't reasons, and therefore the court can set it aside, or require the body to now give reasons. In England, the law is if there aren't, in England actually, the general law is you don't have to give reasons unless there's a request for reasons. And if there's a request for reasons and you have to give reasons, those reasons have to be meaningful. And if they're not meaningful, then the court may require the decision maker now to provide proper reasons, if they can. Our law is somewhat different. It contemplates that there's no obligation to give reasons unless there's a statutory provision requiring that, but the principles of fairness may require you to justify. So you have, it's a fairness, a procedural requirement, rather than a substantive statutory requirement. Sometimes there is a statutory requirement. Well, as part of procedural fairness, the obligation to give reasons, and by that we mean meaningful or adequate reasons, could be reviewed, and it was a standalone ground for judicial review until recently. In 2011, the Supreme Court of Canada, a case called the Newfoundland Nurses, actually my friends would say the Newfoundland and Labrador Nurses, they would insist on the and Labrador. The Supreme Court of Canada held that the obligation to give reasons is not a standalone ground for review. It's part and parcel of the reasonableness of the whole decision. And therefore, you need to look at the whole context of what was being done to know whether the decision was reasonable or not reasonable. But the standard of review is reasonableness, so there's some deference. In other words, the former tendency of the court to scrutinize the reasons as though they were a debenture has been set aside. But a recent decision, Supreme Court of Canada in 2014 called Agrera, the issue there was a person who was trying to get lawful status in Canada, and the minister denied that on the basis that it was contrary to the national interest to provide the ability to stay in Canada. But he didn't say an awful lot about why. And it went to court. The federal court said that the standard review was reasonableness and the decision was not reasonable. The Federal Court of Appeal said the standard review was correctness, but the decision was correct. if you think about that for a minute, I mean, that's just the two opposite ends of the possible scale. The Supreme Court of Canada said the decision was reasonableness, and the decision was reasonable when you took into account not just the written words of the decision, but you took into account everything that was in front of the minister. So all of the submissions, all of the policies, all of everything. And the court could infer into the decision all of that as part of the reasons. I think that's probably got to be wrong. Did I say that? Supreme Court of Canada is wrong. It needs to be thought out some more about what reasons are. And so, having said all of that, one of the jobs of decision makers is to do the decision with a quality that is apparent to somebody reviewing it. Some of that is reputational. Arbitrators in labor matters tend to have a reputation of knowing what they are doing, and that is a halo effect that applies even to a new arbitrator the first time they're doing an arbitration. That the courts say, you know, we're deferential, that reasonableness is a standard of review. We're not going to quickly go there. Some labor boards in the 1930s and 40s and 50s and 60s had no credibility at all, and the courts would just go in there and do everything. That might be true of information and privacy commissioners now. Worker compensation boards had that problem for a while. So how do you get over that? Well, one of the things you do is you get training. That's the first thing you do. You get training, and you are very clear about what the process is. You're very clear about what the decisions are that have to be made. You're very clear about fair process. And when you make the decision, you're able to articulate all the elements that need to be in that decision and to do it in a way that somebody looking at it, and that somebody looking at it actually probably isn't a judge. I don't write for judges when I do it. I write for the losing party. I want them to know I was there, I heard what they had to say, I was awake, I understood what they had to say, and this is what I decided and why I decided it. They may not like it, but they're not in any doubt about what I decided and why I decided it. Or as somebody said, that a ham sandwich is a ham sandwich, from a case that I did many years ago. So you need to say, so what are the skills that you need to have to be able to do that? And it seems to me this kind of organization and this kind of curriculum and this kind of training is really important. It also tells me something else, that if you have that kind of training, that your skills are transferable. They're transferable from one organization to another organization. And over time, somebody who's on the Workers' Compensation Appeal Tribunal, for example, could very easily become somebody on an adjudicator for the Information Privacy Commission. It doesn't matter which one it is. There's some bodies that are so technical that if you don't have the technical expertise or gain it somehow, you would be at sea. But many things, it's process and intelligent decision making is far more important than knowing any of the technical things. The parties will tell you the technical stuff at the end of the day. Well, I've talked for about 45 minutes. Do you have questions? Do you want to talk? Is there something that bothers you, either from what I said or about the administrative justice and administrative process?
I heard you say that in England, in the legislation, they're not required to give reasons for their decisions.
For a certain slice of bodies, the tribunals, those bodies that were governed by the Tribunals Inquiries Act 1958, they only had to give reasons if they were asked to give reasons.
And now, is that still the same?
It depends on which body you're talking. One of the problems is there's so many statutory tribunals. And in fact, England has done a whole bunch of really interesting, England and Quebec and Australia have done some really interesting things in reorganizing their judicial review. So instead of going to courts, they go to, in Quebec, it's the Cour administrative du Québec, the Administrative Court of Quebec. and it sits in panels. So some panels are financial panels, they'd be security panels, some are social welfare panels, and so on. So there's a statutory right of appeal from those first decision makers up to that, not to the court. You only get to the court after that second level. If you get there, in Australia, you don't get to the court at all. It's the second body. We have constitutional constraints here. It's called Section 96 of the British North American Act 1867, or Constitution Act 1867, which would prevent that happening. In the context of making that root and branch change to the administrative justice system, England, because of course Scotland is different, and with a name like mine, Wales is different, and Ireland's different, Northern Ireland's different, but there generally is now a requirement for reasons to be given, but it's not universal in England.
So do most or all Canadian legislative bodies also have a requirement for reasons?
No. I spent most of my day-to-day with the Legal Profession Act on some disciplinary stuff. And as you read it, you realize this body's required to make a decision and give reasons for that decision. That body isn't required to give any reasons. They have a discretion whether to send a citation to the discipline committee, the hearing committee, but they don't have to give any reasons for it at all. And a body giving a decision on the merits of it has to give reasons. A body dismissing, accepting a discontinuance application has to give reasons, but other bodies don't have to. So you have to read the legislation fairly carefully. I would say that there is not a general obligation to give reasons, statutory obligation to give reasons in administrative law across the country. It's extraordinarily good practice. And if you don't give reasons, there may be an argument that you breach the principles of procedural fairness, because after all, how would you know if you have a right of appeal? Yeah. So that's how the courts have got in there.
Thank you.
Yes?
When you talk about reasonableness, it sounds inherently subjective.
It does. And there's a saying in law about subjectivity. It's the length of chancellor's foot, size 9, being a chancellor but in a different context. And of course, what the court has tried to, equity, the law of equity, the chancellor was the keeper of equity, historical. We could have a long discussion about that some other day. The court has tried to structure what it means by reasonableness, and that's why in Dunsmuir the court stated that a decision is reasonable if it's intelligible and justifiable in the statutory and other context, and the outcome is one which is acceptable, open, in terms of the facts as they are and were found, and the law. So it's trying to say it's not just reasonable, as you might think it, or I might think it, or the 40 people who are in the room might all think it differently. Having said that, as an advocate, there's an enormous amount of room and opportunity to cast your submissions in a way as to whether something is reasonable or it isn't reasonable. So if I'm acting for somebody challenging something, I will just go out of my way to figure out, well, now, why isn't this reasonable? That'd be something I'll spend a lot of time thinking about. Why isn't this reasonable? And one of the answers may be it's not reasonable. I'll give you an example of that in a minute. It's not reasonable because when you look at the whole statutory scheme in the context of the whole common law, that's not what the law is. And the legislature never could have intended it to be that way. Or the reasoning process just may be flawed. And one of the things that the law, that the judicial review doesn't do, it doesn't just say, are these reasons, is this decision, are they rational reasons? Do I understand the reasons? It's not good enough. That doesn't get you there. It's got to be reasonable in terms of the statute and the common law and the facts. So in 2008, just before and after Dunsmuir was decided, there was an issue about whether pharmacists could sell prescription information to an aggregator of data. And the data is used for all sorts of things. They didn't sell your name or your address from the prescription, but they did sell your 45, male, and this is the prescription. This not the prescription, but the drug. And that got aggregated. The Information Privacy Commissioner didn't like that and had an inquiry and said you can't do that, and that went to court. And the court held that, and the words, if you read the words in the statute literally, you could understand why the Information Privacy Commissioner said that. But if you read that provision in the context of the whole act, it didn't make any sense. So it wasn't reasonable. So if you read it in the abstract, it was rational, it made sense. But if you read it in the context of the act, it didn't make sense. So there's trying to be a structure of what reasonableness is. It's not just my foot or your foot. It's not totally subjective. But at the end of the day, there is some element of subjectivity in it, because at the end of the day, the Supreme Court of Canada is the last court on this earth. They may be wrong. I didn't say that. But on this earth, they're wrong, but they're final. So coming and going, prairie lawyer, you accept they're final. Thank you.
Thank you so much. Thank you for an excellent overview on, I think we got standard of review, correctness, and reasonableness. We've got role of decision makers in judicial review, and a good discussion on reasons. We are very honored that you were able to speak at this year's annual general meeting, and on behalf of the board and the members of the Foundation of Administrative Justice, as well as everyone here, I'd just like to thank you for a very informative and educational talk. Just a token of our appreciation.
Thank you very much.
Thank you so much.